Where is he gone now? Now, madam, you are present here. If you don't get a satisfactory answer on 19th, your chief secretary will be here on 20th.
I am here, Minister.
Yes, we hope that you have heard the order.
Please, we will satisfy your lordship.
Satisfied now?
Minister,
it is a compliance report and you are saying that you will satisfy.
So, Minister, last order says, Minister, we have to file by 5th, Minister.
Today is 5th March.
Grant me any reasonable time, Minister. We are filing it today, Minister.
The list that is expected is that you should have come with the compliance report when the matter was being heard.
Malas, we are filing it today. Malas, we grant some more reasonable time since your lordships are taking on 19th, Malas. I am deeply obliged.
State of Uttarakhand is there. It's a plain matter which have been pending 6-7 times. We are covered by the JP.
Yes, who is for state of Uttarakhand?
Steady, she's there. She's there for the state.
Don't address this lady directly. Not a. Yes, madam. Have some decorum when you are addressing the court.
Status.
Yes, madam. Who is appealing for the state? Yes, the other co-accuser has already been granted the benefit.
Yes, ma'am. In this case, it's listed before the Honorable High Court for final hearing on 24th of March. Manoj, it's a case of kidnapping and rape of a minor child.
The alert constable for the state.
We have covered in the films.
We have submitted that the matter is already fixed to a final hearing before the Uttarakhand High Court on 24th of March 2025. We therefore request the High Court to take up the appeal of the said date and impose the matter on 1st of April. If it is not taken up that day, you tell us, we will consider it relaxed. Yes, Mr. Chairman.
If your lordships have the paper book for 41, if I can trouble you to take the IA, my lords, 37419 of 25, which is filed in that. Your lordship will find the papers there. Once your lordship's clarification order is dated 10 December, page 24. It's at page 45
Of the IA.
of the page 45. And that's the one. At 46, I can just read that short order. Page 45, 46, para 1.
Yes, please.
Yes. The grievance from the raised on behalf of the review petition of some of the applicants before this court is that though they were in employment covered by the recognition order date also, they believe that the judgment of the order dated 28th November would come in their way if they were to make better their prospects by applying either in other institutions or for promotion level. We have already clarified in the judgment of the region that the one-time scheme is provided solely to safeguard the interests of those teachers who are employed on sponsor date. We are therefore not inclined to entertain the present review petitions as well as business activities. However, to avoid confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 17 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Needless to state, the clarification will be effective from the date of pronouncement of the judgment under review. The date of the judgment under review is 28th November 2023. Now, the advertisement in question here is 29th May 2024. Please note that it's 29th May 2024. And that was for 2,900 vacancies for which a recruitment advertisement. 29th May 24.
29th May 24.
And January, so principal judgment is 28/11/23. So since this clarification applies from there, we have the right to be considered towards this advertisement and for the counselling processes that start. A similar issue rose with reference to Bihar, in which
You were in employment on 10th of August.
No problem. We were in employment in 2017, no cavil on that count, it's admitted. We were in service and we have done the 18-month course as required by the timelines provided under the RTA. All that is not in dispute. Now, in Bihar, when the same issue arose, it came to this court, and if your lordship will see at page 52, just 10 days after your clarification out of 10th December, the 20th December, implementation of the clarification. That's at page 52, annexure 8.2. 20th December. An application was passed. I had occasion to assist before. At page 53, in fact, at the top of page 53, second sentence. Since the Bihar Public Service Commission had issued an advertisement of 7th February 24 for recruitment so-and-so, which is to commence from 23rd December. It is submitted that around 36,000 candidates are in the fray, and the present application is made on behalf of around 215 applicants as per it. The stand of the NCT and the NIOS is both recorded there.
They are supporting you, yes.
Yeah. So paragraph 4 extracts the clarificatory order notes. Paragraph 6. In the interim, we deem it appropriate to allow the participation of the applicants in the counselling process being conducted by the BPS. The outcome of the counselling process, so far as the applicants are concerned, we kept confidential. This is made subject to further orders to be passed this evening. Now, if I can pause for a minute and bring you up to speed, what's happening in Uttarakhand. After that advertisement, they've had a series of counselings that are taking place. In the counter affidavit, because this application is coming up after notice. Notice was issued in the transfer petition first, and then in this IA. The notice in this IA was on 19th February, after which they have filed a counter, the state. Now, in the counter at page 11, the state says that the counselling process is 90% complete. Independently, we filed an RTI and we find at page of the same application at page 95, you'll find there are 278 vacancies at the moment. I'm not troubling your lordship with the page on the reply, so that they can. Just as of the same application, page 95, it's an RTI response. The relevant is at page 96. Bottom of page 96, very last row, it says total number of vacant posts. Last column is 278. So 278 is the number of vacancies. Now, before your lordships, I represent 239 of them. I believe that without in any way disturbing those who have already been counselled, etc., which I would be entitled to ask for, but I don't want to ask for that. Let's not disturb what's already happened. If you've counselled 90% of them, you have 278 present. We are just seeking implementation of your lordship's order. I have copies of a list which shows how your lordship's clarificatory order posts that these have been implemented in the other states of the country. Just the other side. We have just done a little leg of a deep dive to find out what the other states have done. So post your lordship's order of 10th December 25th. Punjab has implemented on 2nd January and then again on 4th February. West Bengal has required an order from the High Court 13th January. That's for one individual West Bengal. Bihar has done it on 7th February, and this order also your lordship saw. Jharkhand is 10th February, Chhattisgarh 12th February. The KVs have done it on 13th February. NCT has issued a letter also on 27th January. Now, in this line, I believe that the same order should be passed where we can be accommodated, because that's the reason that we are the same petitioners who came before you in that review. Same people who have got the benefit of that. Now, at the very least, that should be implemented by the state. I don't know why they're dragging their feet on this.
Yes, madam.
My lords, I did not have the benefit of appearing before my lords when the parent judgment and the review order was passed. But my lords, what is being sought right now is a clarification as to interpretation for the review order.
No, they are only seeking the implementation of our review order, which we have clarified by the review order. We did not entered in the review, but we clarified our order.
To the extent, my lords may kindly see the review order and rather enlighten us as to what will be the interpretation, my lords, because the state will be is in compliance of the parent judgment. Who are the which basically upholds my service rules. My service rules are in consonance with the guidelines.
Therefore, we held that the special scheme was in order to protect those persons who were already in service on such and such date.
My lords,
I still maybe distinctly recollect the judgment. The correspondence between the government of India and the various authorities, the NIOS and all that, was to provide avenue to those persons who are already in employment, so that they are not thrown away. And they had to complete the 18-month course online and all that. So if these persons were already in employment on 2007, then our clarification will come to their benefit.
Clarification, if my lords could kindly see paragraph 3, which is the cause of concern. If my lords could please see paragraph 3.
And you did not have, maybe you did not have the benefit, but Mr. Sethi had the benefit of arguing that matter.
My lords, the matter now, I'm back the matter, so I may not be able to give his assistance.
Yes, we appeal his argument.
My lords, may kindly see
Paragraph 3.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. So the purpose, my lords, my limited understanding is that it had to be for institutions or for promotional avenues. At the same point in time, by the parent judgment, my lords upheld the rules as well. My lords, the new fresh counselling has happened as per the rules.
So therefore, if there are any vacancies to be filled by the state government, and they are already working in some institution on a cut-off date, then they are intensively considered for migration from one institute to another institute, or if they are in the state government for the purpose of promotional benefit. And if you have 278 vacancies, what is the harm in not considering them? We don't say that you appoint them. You consider them their claim.
None of the individuals up till now we have received any submissions with respect to what already there that any individual was removed from service or denied promotion as a direct consequence of the parent judgment. Please see my rules, my lords. My rules have been upheld. My lords must please see paragraph 15, my counter affidavit, and see the rules.
Madam, we have upheld, but at the same time, we are also clarified that all those persons who were in employment as on 10th of August 2017 will be considered as having an eligible diploma if they have completed 18 months for all purposes.
The purpose, that's what I seek my lord's clarification, since it said promotional avenues, which basically would have meant that in the second.
Other institutions would also include the government.
My lords, may kindly see my limited submission. Would it also mean for the Uttarakhand government?
Yes.
That my lords may kindly see. As I said, my lords, the judgment was passed by my lords, and I will be just seeking my lords, rather, it's the other way around. I am seeking my lords' assistance. My lords, may kindly see my counter affidavit.
We will provide you the necessary assistance.
My lords, guidance, a better word, my lords. But, my lords, paragraph 14 and 15 is my counter affidavit. My lords, just see the predicament. My lords, just see.